Welcome to today's webinar. Today's webinar is hosted by Law and Research Network. And my name is Aisha Ayub, and I'm a human rights lawyer, activist, researcher, and today's webinar will be moderated by me. Law and Research Network is a policy think tank and a research think tank. And the core purpose is to basically look at the global international law conflicts, and we also look at the mitigation of international law and global conflicts in a conventional and non-conventional domain. Our today's topic is we look at the discrimination in international law from a global south perspective. And we analyze whether the international law has created discrimination, whether the Western world has created its domination through international law, and how international law creates inequality for the global South, and whether there's a way forward to reconstruct international law. Today we have with us our guest speaker is Professor Shahab Saqib, and he is a PhD scholar at King's College London, and he is his work is based on the conceptualization of discrimination in international human rights and Islamic law. He's a practicing attorney in Lahore High Court, wherein he provides legal consultation on disputes of international human rights law and Islamic law. He's teaching at SOAS, King's College London, and various other universities. Welcome to our today's webinar series, Professor Shahab.
Thank you, Aisha. Thank you for your kind introductions.
It's an honor to have you. Shahab, international human rights regime, is it a new form of imperialism? Is it used as a concept to import the culture of the West? Because the human rights values are universal and they are based on Western beliefs.
I mean, so there's a lot to be explored in that statement, that whether international human rights law puts forward the objectives of imperialism as they were understood throughout the history. So there is no doubt that international law, public international law, I mean, was created through a certain history. There are scholars such as David Harris and others, even Hilary Charlesworth has pointed it out that international law was for a very long period of time just public law of Europe, and the creation through the Westphalian state order and colonialism was eventually something which influenced its mechanism. So international law was something which remained imperialistic in that sense. Human rights law is a very different kind of oriented subject, that it is meant to be for those who are victimized, who are marginalized, who are suppressed. But given that the framework of international human rights law was institutionalized in a way that it had connection with international law, so it never was able to escape this kind of imperialistic, white, Western and Catholic understanding in it. And the way it was understood as an institution and the way it was linked and connected with international law, it always had those kind of connections which were imperialistic in a sense.
So as we were discussing, so has the history of international law, if we analyze it, has it been used by West to create such domination if we look at colonization and we look at the modern international law?
I mean, there's very interesting work on that. And I mean, obviously, there are various scholars, especially the Wales scholars, third world approaches to international law scholars who have been talking about it. But I somehow find the work of Christopher Givers as excellent on this topic. So he writes in a particularly unique way that international law was a racial imaginary. It was a white imaginary that was created by the white states to sustain their dominance in a way it was constructed through colonialism. And that kind of makes sense to me, because if you look at the history and the timing on which international law came to being structured as a form of legal system which was based on legal formalism, and its various structures, the way it was coming, the way the processes through which it was deriving its jurisprudential authority, it kind of resonates through his scholarship that it was a racial imaginary that was constructed in that way. So I think that work is very important in understanding how international law is structured. But there are other works which have conflicted this opinion. Some of these works still point out that international law was and still is an imperialistic project, but in different ways. And obviously, there are so many ways to go around it.
As we were discussing that international law created structures, so these structures basically have they created these structures and processes, have they created inequality for the South? If we look at the IMF and the process, the international financial institutions, so they are imposing the economic policy of the West on the South, and they do not have economic independence. So, what is your opinion on that?
No, that's completely true. I mean, there's a book by, I think, Jason Hickel. I might be. So the book is The Meddlers. So he talks about how these organizations, which are very Western oriented, including IMF and the World Bank, how the entire purpose of these organization is to facilitate a mechanism that is based on inequality. So the book is very interesting, and those who are particularly from global South and especially from Pakistan, given that how we are nowadays continuously reformulating our deals with the IMF, it's really important how in terms of poverty and how in terms of economy, these organizations are kind of working in a similar way those states historically used to work, and how international law is facilitating the formulation and the working of those organizations. So that's true. I mean, and I think that's not even disputable, given the way Jason has written his. I mean, and I would really suggest the readers and those who are watching to go through it. Yeah.
As we were discussing that international structures they have created inequality, and you are saying that it is true. So, if we look at the human rights regime, if we look at the international criminal law, and we analyze the different facets of international law and even international environmental law, for example, so the multinational companies they have been exploiting minerals, whereas if you look at the Western countries, the more developed countries, for example, Canada. So if there has been an oil spillage in US, so they protect their environmental rights. What do you think that why is that discrepancy? Why is that we see a very blatant discrimination?
I mean, I think that what you are referring to is broadly in terms of how the branches of international law work and how international law is situated within that. And I think Chimney has rightly pointed out that one of the techniques of the mainstream international law scholars is that, or international, he calls it mills generally, is that it fragmentizes social sciences, and within social sciences it fragmentizes international law. Then what's the outcome of this fragmentation is that you kind of divide the processes in a way that international criminal law works separately to international environmental law, which works independently from international trade law and international maritime law. So the wrongs which are committed, or which are, I should say, shielded by one of those legal disciplines, are not associated with the other. So what you're saying is right, because in terms of environmental exploitation, if you look at
Shahab,
structures, but this has to be a framework in which how war is. Sorry.
can you repeat that again? Because there was a breakage in internet.
So yes,
We,
I'm yeah. I was just saying that, I mean, international environmental law or human rights law or international refugee law for that purposes cannot be examined in isolation. It has to be seen how the Western Hemisphere is organized around the use of power and how that use of power is biased, and then it creates war and chaos and conflicts in certain countries. And then within those countries, how the refugee mechanism is created. And when those countries are destroyed, their entire economic structure is destroyed, their environment is destroyed, how that replicates into a system which then international environmental law or human rights law cannot protect. So it should be looked as something which one should step back and use the eagle eye to look into the entire framework of international law in that sense.
Shahab, we now moving forward, the TWAIL approach, the third world approach, it emphasizes that the experiences of the people of the third world countries is largely ignored. When obviously the structures and the procedures that are imposed on them, and if we see, as we were talking about IMF, if we analyze African countries in South Asia, so the programs have largely failed, and we've seen more inflation and poverty. So, how important do you think is to incorporate the experiences? We have to look at the culture of the third world countries to harmonize the differences.
Yes, I think in that regard, I would just like to uh, make two classifications, which I think are very important to understand. And one of them is that how international law regulates with the global South states at the state level. And the second one is how it regulates with the people or the races or the cultures or the groups of individuals who live in the global South. And I think that is important, which might be coming out of my individual private research. So there's a caveat there. But I think it's important because, and going back to your question, is because international human rights law, to be very specific, do conceptualize discrimination in a way that tends to protect certain groups, which includes race, sex, members of different color, ethnicity, etc., etc. But there's this weird sort of formulation that this protection is only guaranteed within the states. So there's this kind of Jim Cronian legislation that international law kind of imitates, in which there's a state apartheid that, for instance, a country like Iraq is constituted within its own boundaries, and the people who have their own culture are to be just instituted within those boundaries. The people who follow those religion, the races of that country has to be just minimalized in those boundaries. But and the equality then should be regulated on those grounds for those people in that group and not beyond it. And I think I need to emphasize that, and that's the thing about international law itself, that the cultural kind of integration between those boundaries is never something which international law imagined in a certain way. There is a certain aspect of refugees and migrants which international law looks at, or international human rights law, to be very specific. But the way, and this is why I call it a very structural and systematic problem. And I'm not the only one who has been talking about it. There are other scholars who have pointed it out. I'm just looking the global South or the Whalers perspective to look into it. But the problem is systematic because the conceptualization comes only within the states and not beyond it. And when it just stays within the state, it automatically has a comparator which is very leveled down. And then it becomes a sort of a Jim Cronian structure in which you are separate but equal.
Shahab, you have raised a very important aspect of international law, that the concept of these rights applying to these rights are state-centric. So if we look at, you just mentioned about the they do have refugee laws, and if you analyze with lot of Western states, the European states, they do not abide by it. If you look at Hungary, Hungary was really receptive towards the refugees from the European states, whereas when it comes to the certain specific race, so they have not been very receptive. So, should international law do away with this phenomena of state-centric rights? So, what do you think is the solution to it?
I think international law and international human rights law, to be very specific, is developing. So I'm not an absolutely abolitionist of international human rights law. For instance, it's working uh, in the areas of sustainability and in the areas of climate change. It is kind of having a global impact. Various countries are coming forward and joining the hands on these issues, and that's why you have these meetings of various countries as well. But to be specific, that on the issue of migrants, refugees, and I would just say non-citizens or racialized minorities, and the problem is that it goes back to the history that international law and the conflict it tried to harmonize was never about climate. That's why climate is not an issue, and that's why people can shake hands on that. Sustainability was never an issue. It was essentially about different groups which were trying to dominate each other in different mechanisms, whether religion, whether whatever. So this is where international law has, to a certain extent, failed. I mean, I would say that there are still certain courts which are working in a certain way and giving rights to certain migrants. You would eventually, like in the UK, you would have seen that the Rwanda expulsion of certain migrants to Rwanda was stopped by the courts in the UK. Then the Supreme Court eventually gave that direction, but the European Court of Human Rights stepped in, and now there's still continuous battle. And our Home Secretary is saying that it's her dream and obsession to expel the migrants or deport them. So there's this continuous ideological battle that is going on between, in which international human rights law, the way I look into it, and I think people should start reading Kos Kenyami's work, because Kos Kenyami is kinds of takes a neutral position, and he kind of gives this pendulous image of international law in which it keeps shifting between apologetic and utopian end. And this is what I think international law has eventually developed to be. So sometimes it sides with those who are imperial, sometimes it sides with those who are marginalized. But the way I was describing it was that eventually what's happening is that it should be siding with those who are marginalized. And even if in some situations it does help them, overall, the impact it was supposed to have, it's not having.
Shahab, so the idea of race and capitalism, does it create subjugation of third world countries?
So the idea itself, I think the idea of race itself, I would probably further specify that the way race is understood Eurocentrically, yes, that is problematic. And capitalism, obviously, I mean, as someone who is from subcontinent, would probably know that the entire process of colonialism within India was never a race oriented endeavor. It was never even a war oriented endeavor. It was East India Company which came to India for trade. And it was eventually a process which was based on exploiting certain groups within those countries, and it came in the form of trade. And how that trade eventually led to a colonial structure in which India was overtaken. So, and history is quite clear about it. Like even in the US, in Africa, the entire processization of or industrialization of the Europe started through this mechanism of wealth generation. And within that wealth generation, race was eventually a victim, given the fact that the slaves who were usually used for trading were brought from Africa or India. The labor which was exploited were from those regions. And this is why the critical race scholars always talk about that you can't understand race without capitalism. And the emphasis on race and capitalism to understand the global inequality is because we're still living in a world which is very capitalistic oriented. And within that orientation of capitalism, we do see that there are some holes, there are some pockets in which capitalism breaks down the barriers of race. So, for instance, if you are a rich Black person and you are happy to exploit certain groups, or even those who are subordinate to you, what you will get is you will get a lot of appreciation. Like you can open companies around the world, you can do what I mean, albeit it's through its own limitations, but you can do that. But if you are not, if you are poor in that sense, you do not have that power that it generates. And this is also why people call it a crisis of liberalism, because the more power you get through capitalism, the more you start subordinating the other groups. And this is one of the reasons the marginalized groups, even the feminist scholars, talks about it, that how this creation of wealth in a certain way is eventually oriented towards men, and how even some religious scholars talk about it, that it fundamentalizes and then furthers the interests of those who belong to those kind of thinking. For instance, interest-based dealings are not something which are permitted within the Muslim framework. And obviously, those who will be benefited by it who work in the other kind of frameworks. So, yeah, these things are not just interrelated, these things are fundamental to understanding how the overall system works in terms of inequality.
So we have discussed how the race and capitalism both are interlinked and how they create inequality. Moving forward, we know that we cannot do away with international law. So, do you think that international law needs to be deconstructed and a third world perspective needs to be added? And as we were discussing, that the marginalized, the race, maybe the religion, and different voices, all these need to be incorporated, and international law needs to be developed from this perspective.
So right. So this is something which I've been discussing by with the critical legal scholars, and I think there's a large group of scholars who agree on this fact that the way international law is structured at in its current position, the emancipation of the third world is not possible without dismantling the entire structure from the very root. So this opinion exists. And I do think that this opinion has its worth. I have relied on this opinion on various occasions. But there's also a general realization that given the advancements of technology and the way it has developed in the current contemporary world, doing away with international law may generate other mechanisms, but the cost of generating other mechanisms, let's say, if it's argued that well, global south can be emancipated without international law, but you have to go through a nuclear war. So the costs of that are very, very high. And this is why those scholars who still think of international law skeptically, they kind of emphasize and assert that we have to understand international law as a legal formalistic tool, as an instrument, and go strategically through it and use the mechanisms to give the certain group certain rights. And I mean, Tendai Chiumi's paper, Migration as Decolonization, is something which I just thought was very interesting in that regard. And I mean, this is one of the things which the conservative belt hates as well. Like if you've been following again the conservatives in the UK, they are saying that well, we have a system of asylum and migrants, but the lefty lawyers, that's how they use the term. The lefty lawyers exploit the generous kind of suitability or the generous kind of regard given to these asylum seekers. And I think one of the reasons why this happens is because this is how you will strategically manage a chaos. There's no other way around. Just like as a lawyer, if someone, I used to deal with family cases as well. And if there are certain grounds you can rely on for a divorce, and a woman is facing something different, and she cannot get a divorce on that ground which she's factually facing, you will rely on the grounds that exist in the law. You will make up a story, you will falsify your narrative. And this is the problem with law in itself. So this is, I think, how strategically those who argue that we can use international law are still using it. But again, this is also something which is very controversial. So for me, I think both things are very important. There needs to be a theoretical level of intervention in how international law is structured. and fundamentally challenge it, while you also have to practically use the framework to put forward the interests of those who are marginalized.
Thank you so much, Shahab, for your time today. And we were really honored to have you on our webinar series. So, what you proposed us was that there needs to be an amalgamation of basically that you need to work through law also, and there needs to be a theoretical intervention also. And international law needs to be all inclusive, and it needs to consider the perspective of race and class and women and marginalized groups. So because we have to work through the system, otherwise there's a big cost, as you said, that uh, in the right now we cannot replace it with another system. So this is the best option we have to work through right now. And until we come with our next series, thank you so much, all the participants who've joined us today. And thank you so much, Professor Shahab, for your time today.
Thank you so much, Aisha, for inviting me.
Thank you so much.